All right, well, I have 12 o'clock here, so we will go ahead and get started. Our speaker today is Maria D. Plesy, an associate at Henson and Efron, PA, in the Estate Planning, Trust, and Probate Practice Group. Her practice involves assisting individuals, fiduciaries, and corporate clients with their estate planning and trust and probate administration needs. She received her JD from the University of St. Thomas Law School and her bachelor's degree from North Dakota State University. Please join me in welcoming Maria.
Thank you for that introduction, Sarah, and good afternoon to everyone who's joining us here today. Our day looks a little different, not being in person, but we've all become accustomed to it, and what a relevant topic to be talking about today than estate planning in the digital age. Today's presentation will focus on considerations for assisting clients when they're managing their digital assets, identifying what those assets are, and then ways for a smooth administration to occur when digital assets are being administered. To start our presentation, just wanted to give a little bit of background of my firm. Henson & Efron has been in business since 1976. Attorneys at the firm practice in a variety of different subject areas. We focus in areas of business and transactional law, estate, trust, and probate that I operate in. We also have a large family law group, do litigation, real estate, and tax law as well for our clients. When I'm not at home, my home office, I'm usually found in the US Bank building downtown. On a personal note, I was recently married, hence the name update, if anyone caught that. I graduated, as Sarah indicated, from St. Thomas in 2017, and from the start have been practicing in the area of trust and estate administration. I help clients with succession planning, whether that's preparing revocable trusts and wills, assisting with family and business succession planning. And I also do a lot of work with probate and trust administration. So helping clients prepare for the inevitable and then helping their families administer their estates and make sure things get to where they were supposed to go. So for today's presentation, I have just two objectives for us as we go through the material that I prepared. First is identifying what clients' digital assets are. What is considered a digital asset, and then how do we handle that? So identifying what they are, and then understanding estate planning issues that may arise during an estate administration, and things that need to be addressed when we're dealing with these very special and somewhat unique estate planning assets. So first, we have to ask, what are digital assets? Well, let me look here. The Revised Uniform Fiduciary Access to Digital Assets Act defines digital assets as they are, as this appears here on your screen. So an asset that's an electronic record in which an individual has a right or interest. The term, however, does not include any underlying assets or liabilities unless the asset or liability is itself electronic record. So under this definition, devices including computers and smartphones, tablets, anything of that nature are not digital assets, but the data that's contained on them is a digital asset. So Word documents, emails, text messages, those are all things that are considered digital assets. Minnesota adopted this Revised Uniform Fiduciary Access to Digital Assets Act in 2016. The act allows internet users to plan for the management and disposition of their digital assets. Prior to RUFADA, as some call it, the Storage Communications Act, which was a part of the Electronic Communications Privacy Act of 1986, really limited an individual's ability to provide access to their fiduciaries after they had passed away. This was based in privacy concerns, and the user's digital assets were considered private from their estate administration. So it really kind of tied the hands of the fiduciaries to be able to get access to any digital assets that a person may have owned. Now, with RUFTA in place, consent can be granted to fiduciaries either in an online tool such as internet service providers, Facebook, YouTube, Instagram, wherever you may be online. Some of those platforms allow you to directly indicate where you want your assets to go or who you want to have in charge of those assets. Otherwise, you can designate in a will, trust, power of attorney, or even a specific digital property authorization who should have access to those assets, again, when you're unable or the user is unable to access them. If there's no direct consent provided by a user on that digital platform, the custodian's terms of service will control. So again, if someone does not identify who they want to oversee their, let's just say Facebook social media account, the terms and conditions under which Facebook operates is going to control. If the terms and service don't address any fiduciary access to digital assets, then the default rules provided under the Act will provide and allow for the management of the digital property, which can include, again, computer files, cryptocurrency or virtual currency that the individual might have owned, but it may limit access to protected electronic information if, again, specific direction has not been given. So to break it down further and separate from, I'm just getting a, looks like I'm getting a little bit of a issue with my computer camera. It's beeping at me, but see if I can figure this out. Just one moment as I have these. Well, I'm just going to try to ignore that beeping in my ear. All right. Excuse me here. All right, well, we'll continue. Can everyone hear me okay? Sarah, can I have you acknowledge if you can still hear me?
Yes, we can still hear you just fine.
Wonderful. Sounds good. Thank you. I'll carry on here. Sorry for that slight interruption. So when we're talking about digital assets, it's a large umbrella under which a lot of different things sit. So thinking generally as a digital asset, it's intangible personal property. It's any non-physical item that's either stored on a computer, a phone, a simple USB drive, or even online in the cloud. All right, data is one type of digital property in that is it's electronically stored information, right? Found on a computing device or in the cloud. So it could be photos, voicemail, text messages. However, once that data is printed or converted into a tangible piece of property, then it becomes tangible property and can be disseminated that way. User accounts, which we've talked a little bit about before, those are accounts such as user's YouTube account, Facebook, Microsoft, Amazon account, even gaming profiles or blogs that may be used by a user. Those are all considered digital assets. Virtual currencies or cryptocurrencies. One of the most popular crypto virtual currencies is Bitcoin. It's a virtual medium of currency and has fluctuating value, right? But there's no tangible form of it. It is important to note specifically when it comes to cryptocurrency, if you have ever a client who has this type of an asset, in order to access their currency, they have an encrypted digital key, which allows them essentially the password for them to access those assets. That's very important and cannot be lost. If it's lost, there's no way to recover it. So as we get more into the management piece of the presentation, how clients should be managing their digital assets and keeping record of them, that is one thing that's very important and essential, again, because if it's ever lost, it cannot be recovered. Specifically, Bitcoin has seen dramatic rises and falls, and it has made news headlines in the past years. One thing I found interesting as I was preparing for the presentation and just looking generally into cryptocurrency and virtual currency in the past for clients is that back in May 2010, Bitcoin still was relatively new. It was an individual in Jacksonville, Florida. He paid at the time 10,000 Bitcoins for 2 large Papa John's pizzas. It didn't indicate in the story what type of pizzas he purchased, whether they were one toppings or supreme. But in any event, he paid 10,000 Bitcoins for those 2 large Papa John's pizzas. Just 7 years later, in May of 2017, Bitcoin's price hit over $1,800 per Bitcoin. So that would have made his, well, at the time was a $41 pizza order in 2010 into an $18 million pizza order just 7 years later. So as you can see, that type of an asset has great value for a client, and ever misplacing or losing an encrypted key of something of that nature, or just not informing individuals that you had that type of an asset could be very costly. Next, domain names are also considered digital assets. So they're separate from the data that's shared on the actual website. But having the right domain name can be a very valuable asset. There was a Ford dealership, I believe, up in northern Minnesota, who was able to secure the domain name of DallasFord.com or something of that nature. Well, they were able to, when they were changing, restructuring business, doing some marketing changes, and I believe even changed their name, decided to sell their domain name. Well, they were able to secure a pretty penny for that name, as you can imagine, because it would have been so popular for dealerships in the Dallas, Texas area. Again, not something you would think of or consider, but certainly something of value to someone, as the high searchability of that domain name would cause value for its owner. Finally, intellectual property, copyrights, patents, trademarks, digital art, photos, music, writings, all those things also considered digital assets. And again, they're at the bottom, the RUFTA definition of a digital asset. So next, here's on this slide here, just, as we all know from the last year, and even prior to that, our online presence is ever growing, right? For some of us, had to jump into the deep end of an online presence, which was caused by the pandemic. But even in years prior, as the chart indicates, the number of social media users by generation in 2019. When it comes to digital assets, it just can be easier to store these types of items either on our computers or online. These types of assets hold both emotional and sentimental, emotional as in sentimental value and economic value. Our PayPal accounts, blogs can sometimes hold economic value for their owner. And we, as estate planners, are charged with helping our clients manage all of their assets, not just something that is maybe included on that inventory or balance sheet when we initially look at things. While most digital property has little or no financial value, there can be significant value if we know what to look for. So again, intellectual property rights on digital assets can be very valuable. Blogs that individuals have created, or perhaps they're a social media influencer and they generate income by promoting products. There's also value separate from intellectual property rights that are relatively new types of digital property. Again, digital currency, advertising revenue from web pages, and even video game characters and their virtual items in their virtual worlds can have value to them that wouldn't be something that we would think of top of mind. Another interesting statistic is that in 2016, the money spent on digital advertising exceeded money spent on television advertising for the first time. So again, that was just 4 years ago. More advertisers know where their target market is. It's online and an online presence. It's not necessarily TV advertisements that's reaching the people that they want to. So now as we dive in a little bit to helping our clients manage those assets. So as we all know and preach, planning is so important, right? Failing to plan is planning to fail. And so we want to help our clients understand what their digital assets are first, so that they may know to disclose them to us. But then the next step we have is making sure that we assist them with preparing those assets to be administered after they're no longer around.
Maria, we have a quick question from the chat.
Sure.
The question is, can you please provide a citation for RFTA and the correct acronym, please?
Sure, I can. Do we want to send that into the chat?
Yeah, that would probably be the easiest.
Sure. Okay, so I can let me look here. Do I have access to the chat here?
I think you should.
Maybe I don't. Okay.
If not, I can add it and we'll get it to you.
Perfect. Yeah, maybe we can do it that way. Just so I can keep rolling here. But yep, the Unified Fiduciary Access to Digital Assets Act, again, enacted in Minnesota in 2016. And I can pull up the Minnesota statute citation for that as well. But great question, and thanks for the comment. So again, planning is important. Clients need to know what their digital assets are and then how they can prepare and plan for them. Planners should encourage clients to prepare a complete list of passwords, usernames, and other digital assets, and keep it up to date. That's the most important piece. That's really going to help their fiduciaries and family members find those valuable and significant online assets, user accounts, or digital property. It's going to keep costs down when it comes to administration and provide for a smooth administration and ensure that no property is overlooked. So just generally for online transactions and password protection, it's recommended that passwords are at least 14 characters long and use a mix of letters, numbers, and syllables, right? Certain online providers provide for additional encryption. They'll also provide or self-populate passwords that are then saved and processed, which is a great tool, something I use myself. The important piece, though, is that clients understand that while those are all kept and stored in one spot, there's a password that enables them to access that. So it's important to have that someplace that's accessible to their administrators. There's also online password protection and password websites that maintain and log those for clients as well. LastPass is the one that's coming to mind at the moment. Again, allows for them to have one place where they can keep everything safe. Accessibility goes to having clients again manage those passwords and usernames, keeping it somewhere that it's organized and again still protected. I've been told in the past that you should treat your passwords like you do your underwear, change them often, don't share them with others, and don't leave them lying around. So it's not very helpful to have a list of your passwords and usernames, but then stick it in the desk drawer of your desk, at your office. that's not keeping it very safe from others and hacking into any of your accounts. So as we discussed a little before in the presentation, is online user accounts each have their own policies and procedures that relate to digital assets of the user, right, and the accessibility. For some online user accounts, the service providers won't reveal or reset an incapacitated or deceased person's passwords, even though a duly appointed guardian or conservator or personal representative or power of attorney has been appointed. As an example, Facebook uses or has memorialization settings that a user can log on and designate a legacy contact who will be able to monitor and make decisions about their account once it's been memorialized, or they can direct the account be deleted when they pass away. If clients have planned ahead to provide clear authorization to the extent that it's possible under the terms of service of each of their accounts that they're using, fiduciaries may be unwilling or unable to attempt to access that online account because, you know, there are, again, as we mentioned before, the Stored Communications Act and other privacy laws that hinder the access to those assets. That's why it's so important to plan ahead. So clients may want to execute an authorization and consent that allows their fiduciaries the ability to access their digital assets if they, in the future, ever become incapacitated or when they pass away. There are sample authorizations. Minnesota CLE has a few authorizations out there, both to include in the client's will or trust, and also standalone authorization that they can sign that would allow for any attorneys, in fact, that they have appointed, again, to be able to access those assets in the event they became incapacitated and needed access. Fiduciaries should keep in mind that some account providers will delete user accounts or certain contact if it hasn't been accessed in a certain period of time. And so, you know, especially when you're dealing with individuals that might have been operating their own businesses, those records need to be managed online very quickly and accessed as soon as possible to make sure that those are maintained. Just a quick story from one of my own personal experiences. We had a young gentleman who passed away. He was living in Minneapolis. He was about 27, 28 at the time. He died unexpectedly from a heart condition that his family didn't know that he had. But his parents came. He was originally from out of state. They came to help assist with the estate administration, get his personal belongings out of his apartment that he had in downtown Minneapolis, and they came to find no paper trail. He had no bills ever delivered to his home, no bank statements. They had no idea what his assets were, if a probate was even needed. They had to wait until they started receiving delinquency notices or notices that finally did come in the mail that related to what his assets were. His family really, they couldn't even get into his computer because they didn't have that computer password to access photos or get other records that related, to any other digital assets that he might have owned. It really did make a sad situation even more stressful for them. And at that point, they needed to enlist professionals to be able to try to access this computer and get into his files to again just see what his assets were and collect those photos and other sentimental items of sentimental value that he had stored there. All right, so when we're talking about protecting digital assets, there's kind of two main pieces to that. One is client precautions, things that the client needs to do to ensure that they're adequately protecting the digital assets, and then administration considerations when it comes time to make sure that an estate is properly administered and any digital assets are managed and marshaled well. So as we've said before, planning is really important. Clients' wills and trusts, all of their estate planning documents should include provisions that discuss digital assets and authorize their personal representative or their trustee to have access to these assets once they passed away. During their lifetime, a digital asset authorization can allow for an attorney in fact or some other individual that they name to be able to access their digital assets and provide them access in the event that they would become incapacitated. Clients need to keep their records up to date. They need to know what their assets are, where they're located, because unlike bank accounts or other financial assets, unless you know about them, it can really be hard to track them down. So should be encouraging clients to keep a document or asset location service updated with copies of how they access their digital assets. Because really keeping in mind, and tracking these types of things can make their life a lot easier and smoother, but also for the life of their fiduciaries and later on their administrators. There are some web-based services that are available that can, store electronic lists of passwords that we talked about a little bit before. But there's also some that provide a mechanism for authorizing fiduciaries or family members to access that list. So essentially, the account owner would inform the company in advance of which key people can have access or unlock their information at the appropriate time. And then after being contacted by that fiduciary or family member, the company can grant access, obviously after a verification process occurs. And even some companies will take a proactive approach, and they'll contact the person on a regular basis to make sure that they're still alive or not incapacitated. And if they don't receive a response within, a certain amount of time, they'll send an automatic email to that person's designated family members or fiduciaries and advisors as well. So again, depending on the level of assets and value of those digital assets that your clients might have, it might be a good idea for them to look into these types of services. Again, just to help with the planning process and management of those assets ongoing. So as we discuss a little bit about the administrative considerations, personal representatives and trustees, as well as attorneys in fact, need to be advised to look for digital assets, and those that have value should be disclosed in inventories, accountings, and even in tax filings when it's appropriate. As fiduciaries, personal representatives and trustees and powers of attorney have a duty to manage those assets for the user, and after that person's passed away, they have to marshal those assets, collect them, assign values to them, and administer the estate. So a fiduciary, once appointed, should search for these assets. One way that they can do that, if they have access to the decedent's computer, is to search browsing history, email if that's possible, and see what accounts the user might have frequented or had accounts on. That way, they can at least have a better idea of what they might be looking for. A computer or smartphone that is password protected and that password's unknown, a computer security forensic expert or a device manufacturer may need to be employed to assist with getting access. One thing to note is if a decedent has failed to plan, right? They haven't authorized their fiduciary to access their digital assets. The revised Uniform Fiduciary Access to Digital Assets Act is going to provide some defaults and allow them the authority under the Act to follow the procedures that are set forth in the statute to access those digital assets. Again, they're going to have to be appointed by a state probate court to have authority to act on behalf of the estate, but under that act, they have some default rules in there to gain access. So if the state where the estate is being ministered has not adopted the act, then a court order may need to be obtained to compel the service provider to provide that information. So again, as we talked about, we got to locate those assets and collect them. We have to assign the appropriate value, and then we're gonna have to sell and distribute those assets accordingly. Obviously, as a personal representative or a trustee is administering an estate or a trust estate, they're going to want to first contact service providers if they can to see if they can get information released. If they've been authorized to do so, they can provide copies of that authorization, and if not, they can then seek the advice of one of us as their attorneys to gain access to that information. As a last resort, if authorization hasn't been given, it is an option for fiduciary to use the decedent's username and password if it's available to access those accounts and directly obtain the information. However, they have to be careful that it's not construed as unauthorized access, right, under federal or state criminal laws. So again, they're going to want to just proceed with caution. If a client is on top of it and has already authorized their fiduciary to access that, they can breathe a little easier in accessing those documents. But some caution does need to be taken. One specific note, again, just because cryptocurrency and virtual currency is such a unique asset in and of itself, it's special to note that once a person passes away, cryptocurrency is treated for federal state tax purposes as tangible personal property at that point, and its value is included in a decedent's estate, and it may be subject to estate tax if their estate is large enough. If there's no income tax due there is no income tax due on cryptocurrency. Rather, it's as a result of the owner's death. It's a capital asset, and so if it is converted in cash during the administration process or later sold by any of the beneficiaries, any gain that is taken by that asset has to be declared as income, and it's subject to either long-term or short-term or long-term capital gains tax, depending on the amount that was earned between the value at the time the owner passed away and the date that it sold. So that's very unique in and of itself there. And if a client owns that type of an asset and they're considering putting it into a trust for long-term, they likely want to include language in the trust document that prevents the trustee to hold the asset without violating any prudent investor rules, and which would require, again, the trustee diversify those assets. So just as a recap, objectives here were to, again, identify what clients might hold that are their digital assets, what the value might be, either sentimental or economic value that they assign to those assets, seeing what they want to happen to those assets, who they want to set in charge of administering those assets specifically, and who they want to authorize as their fiduciaries to administer their estate overall, but also giving special consideration to digital assets that they may have. And with that, I just want to see if there's any questions. I see you ended a little earlier than I was expecting, but if we have some questions, I'm happy to take those at this time and see where we go with that. And it looks like looks like I can access our chat box here.
So if you have questions, please enter them in the chat and we'll respond to them. I actually do have one question. What strategies would you advise someone to do in a situation where a fiduciary has been designated in a will to handle these digital assets, but there is no record of what those might be? Can you talk a little bit about how that would typically be handled?
Sure. Well, I would say because the act is so new, right? And as advisors and planners, we typically want to make sure that we have all of our bases covered. So first, I would kind of examine the the person that passed away, right? What may have been their assets? Did they have a home computer? Did they have a cell phone that was internet enabled? Are there things that we can look for there? Because it's quite possible that the provision was included as kind of a boilerplate provision in the person's estate plan, and they don't in fact have digital assets that actually need to be marshaled. Maybe nothing of significant value. Maybe it's just if they had social media accounts, their social media accounts that need to be tended to. But if there's no evidence overall that person had, they weren't writing a novel, writing a book, and had the manuscript on their computer or anything like that, it's quite possible that their digital assets were that of sentimental nature, and there weren't any that need to be addressed more than just disseminating family photos, things of that nature.
So it looks like we do have a couple of questions in the chat now. The first one is, where can I get a sample digital asset authorization form?
Great. Oh, there are a few online. If you have access to Minnesota CLE, they have provided one. I'm also happy to share the form that our firm uses. Sarah, I can probably send that over to you, and you can have those materials posted. But we typically do provide authorization within a will and trust, authorizing specifically the person representative or trustee, but then also a standalone authorization, allowing any attorneys in fact that may be acting on behalf of the principal for them to be able to access those records as well. So I'm happy to share that that language that we use.
The next question is, you mentioned involving a device manufacturer to access a locked device. Have you ever successfully followed this process, and did it require anything beyond the death certificate? Was there a fee?
I have had clients, yes, that employed either forensic expert to do it or a device manufacturer. I want to say that the two times that we've had that I've had administrations where it involved something of this nature, the device they were able to go with a forensic expert and kind of get into the password, break the password and get in using that way. And so the device manufacturer ended up not being needed or helpful in those situations. It's my understanding there usually is not a fee. If a forensic expert is involved, there certainly is. If the person doesn't have a probate initiated, or there isn't a trust administration going where there's a personal representative or a trustee, presenting a death certificate and the person's relationship to the decedent may be sufficient. Otherwise, you're likely going to need either letters testamentary for the personal representative or a copy of the trust or a certificate of trust, just to again indicate to the manufacturer that you in fact have authority to act on behalf of the estate or the trust and that person's assets.
The next question, are most attorneys that are experts in 521A, which is Minnesota's Uniform Fiduciary Access to Digital Assets Act, are most attorneys that are experts in that millennials?
I would, I can't say that for certain, but I would think that, it's an area of interest for us in this age group, right? Is again, more and more people are online and have these types of assets. I read somewhere the most common owner of that cryptocurrency, right, is young men making over $75,000 annually. So there's certainly interest in this area. But one of my attorneys who's not a millennial actually is one of the experts we would consider at our firm. So I wouldn't say all, but most might be an accurate statement.
Let's see. Are there any additional questions? I'm not seeing any popping up at the moment. Okay, here we go. A couple of questions. Has there been any interesting case law to review on this subject? And I guess the related question, have you seen litigation related to getting access to digital assets? So if you can just kind of talk about how the courts have maybe addressed this.
Sure, sure. There has been case laws. We start, as I indicated, the Stores Communications Act initially, I think, is what kind of prompted the revised Uniform Access to Digital Assets Act, because so many fiduciaries were having problems and running into issues when they would, go to access an account of someone who, their family member who had passed away, and they were, hit again and again with roadblocks, saying that the service providers themselves didn't have the authority to disseminate the information, or were prohibited from doing it because of certain, privacy laws and considerations, right? So that was really the prompting of it. There have been a number of cases involving Google and their service provisions, and Facebook. Again, probably something I can circulate to Sarah, some of the more recent cases that have come out in this, because, as you can imagine, a lot of people have these types of assets that are out there, and if they haven't been properly planning for them, there are quite a few hoops then that their fiduciaries have to jump through to make sure they can get them. So Sarah, why don't I do that as well then, is circulate some cases to you then too.
Absolutely. Our next question is somewhat related. So, any notable litigation on this act in other jurisdictions that have adopted it? And then the second part of this is, with family around the country, are there notable jurisdictions that have not adopted the Uniform Act?
There have. I believe there's 38 current states that have enacted the revised Uniform Fiduciary Access to Digital Assets Act. So there are still a number out there that haven't. So again, if individuals are administering estates or trusts in a jurisdiction that hasn't, their only option may be to go get a court order to access the information if, again, the service provider isn't working with them, or is claiming that they can't disseminate the information without proper authorization. Again, I'm not certain what jurisdictions haven't, but currently there's about 38 states that have. Looks like I might have had one question that was just sent over to me, Sarah. I'm not sure, and I'm not sure if you're seeing the same one, but it's just adding a power of attorney that a person has the right to access all digital materials sufficient. It would certainly depend on the wording that's used, but I would strongly encourage a standalone authorization that refers to the act, that refers to the individual who's granting authorization, that it's their lawful consent to the use of any of their digital assets, and really include the language of the statute to ensure that it complies. So again, just a blanket, this person has right to all my digital assets might not be sufficient. I would look at using an authorization to do that.
Another question just came in. Is there any effort to add a provision to the state statutory power of attorney form?
That's a great question. I'm not aware of anything that our legislative committee is taking that on. But it's something I think that they perhaps should consider. It would be good to have that included. But again, we revised our statutory short form power of attorney, I think, back in 2016. So I'm not sure that they'll be looking to look at that again so soon after. But it would be it would be a thoughtful revision to make, I think, and add that in. But I have not heard any scuttlebutt that's in process.
Great. The next question, do you have any experience with dealing with Apple specifically? They have a reputation of being highly protective of all passwords, etc.
I haven't. Any clients that I've had who have had, Apple products or access it's been usually a family device, so everyone kind of knows has access to it. But you're right, Apple does somewhat have a reputation for being highly protective. And again, I think that's why it's important that clients keep that curated list. Again, whether they're keeping that online or they're keeping it somewhere else, a handwritten list, and they keep it in a safety deposit box or something of that nature, which can be tough, again, just because passwords can be changed quite often, right? But again, for notable assets, for things that really are of value and a person wants their family to be able to have access to, taking those extra steps to keep them in place and organized and accessible is what's really important.
The next question. My will has a provision that all my social media accounts are to be deleted when I die. What should I do to make sure this actually happens?
Great question. Well, it's good that you first included that in your will. What you should do is go to your Facebook account directly and see to it that within your memorialization settings that the account does in fact get deleted. Because if that's your wish, similar to for those that are familiar with beneficiary designations, the account itself kind of it trumps whatever might be in your will. So having and including a provision in your will certainly lets your fiduciary know that was your wish and your intended purpose. But going to the internet service provider themselves or to to Facebook in this instance to ensure that that's reflected within their terms is what's important and what will happen automatically once they receive notice that you've passed away.
And it seems like a lot of the social media platforms make it rather difficult to find those settings. Do you have any advice on where there might be a good summary of how to find those or how to keep up to date with the changes to that?
Sure. Well, usually, I mean, if the change has been made to an account, you'll, like we all do, receive those emails that Google's updating their privacy policy or someone is doing something else, right? So keeping on top of those is always a good thing. I know it can seem a little daunting to maybe look it over, but if it's something that's important to you or your loved ones that happens that way, then keeping track of that is always good. But generally, I find actually most accounts, most providers, if you're on their website and just doing a search for, deleting my account after I've passed away or things like that, they actually do have usually pretty interactive or at least helpful either frequently asked questions sections or kind of tutorials to take you through how to make those changes if they're available to make. If they're not available to make, including provisions in your will or having conversations with your fiduciaries that will be acting on your behalf is important, and in documenting that where you can, because those things are, again, they're important, and if a person wishes to have their accounts deleted and terminated and no one have access to them, they have that right to do that and to designate that to occur.
Great, thank you.
Absolutely.
If there are any additional questions, please go ahead and enter them in the chat. I'm not seeing any that are coming to everyone or the organizers, but I guess while we're giving people a chance to type, one question that I might think of is, obviously this area is changing so rapidly. What changes do you do you see potentially in, down the line here on this, on the subject of digital assets?
Mm-hmm. I think you're right. I mean, things are changing. I think what we could see is maybe more of a breakout in the different types of assets, right? Because right now, what constitutes a digital asset or digital property is fairly broad, right? Anything that's included anywhere on any type of device or in the cloud, right? So what we might be seeing is more delineation specifically when it comes to accounts and specific authorization related to each of those types of different assets. But I think one of the things I think we've already seen movement towards is more of the service providers taking it into their own hands and allowing users the option to delegate and designate things themselves. And so we might see, more and more of an increase of that, and just more common knowledge that's I think part of our piece as planners and counselors is to let clients know that some of these tools are out there and they should access them. But in any event, they need to plan for it and they need to have the right tools in place to do that. So, I think we'll just see continued movement, like I said, delineation between different types of assets, and it'll be interesting to see as times change how this specific area changes as well.
Great, thank you. I'm not seeing any additional questions here. It looks like we have a comment for finding the memorialization settings on Facebook. It's under the general settings. If there are any more questions, though, please enter them in the chat at this time. Well, I'm not seeing any others. I don't know if you have any closing comments you'd like to share, and we're getting close to 1 o'clock, so we can start wrapping up if you'd like.
Wonderful. Well, thank you, Sarah, for organizing this discussion today, and thanks for everyone for tuning in to listen. I'll learn a little bit more about digital assets and assisting your clients and yourselves to manage these different types of assets. Because again, as we take more and more of our life online, it's important that we are mindful and manage these assets well for ourselves and for our loved ones when that time comes. So thank you, and thank you for all your questions today. Very thoughtful questions. I'll make sure that I circulate, Sarah, to you an example of the authorization that our firm uses and provides to clients that can be put out there, disseminated, in addition to some of the case law on the Act here in the Stored Communications Act as well, that the viewers may find interesting and helpful.
Great, thank you. We'll post that to our website with the recording of this session at a later date, and we'll share that with everyone who attended today. So thank you very much for attending our session. We can go ahead and end there.